Hello and welcome back to our Chapter 2, The Legal Environment of Forensic Accounting. We are going to cover Learning Objective 2, which is to describe the classification or categories of law and the basic structure of a civil trial, which include 3 stages. Law can be classified into 2 categories, public and private. Public law regulates the relationship of citizens with the state and serves to protect the public interest. The 3 major divisions of public law are criminal law, constitutional law, and administrative law. Subdivisions that commonly involve forensic accountants include tax law, labor law, bankruptcy laws, environmental law, banking laws, and securities law. Private or civil law regulates the relationships between individuals or entities within a state and serves to protect or determine their rights and liabilities. Divisions of private law that commonly involve forensic accountants include divorce law, contract law, tort law, property law, agency law, partnership law, corporate law, and sales law. Throughout, we will highlight similarities and differences between civil and criminal law. Civil or private law defines and protects individual rights, whereas criminal law defines conduct prohibited by legislative bodies like the state or federal statutes, and thus serves to protect the authority and welfare of the state. So this figure shows you the classification of laws, public and private, and then all of the different contract laws that relate to each, as we mentioned in the previous slide. Where most of us know about a justice system comes primarily probably television shows or movies. And such portrayals are entertaining, but they're not really representative of reality. So here's 5 key differences in the law. So the law is not fast. There is no 1 or 2 hour litigation. Civil trials commonly last 2 days, following a year or more of pleadings. There is rarely ever a gotcha moment, like, the discovery process, which we'll discuss later, serves to eliminate such surprises as trial. And witnesses are generally well prepared by their legal counsel. TV shows are all about drama, so given the extended discovery process, real trials, aside from the verdict, rarely provide much drama. That is, unless you are the plaintiff or defendant, I'm assuming. So jury selection and opening statements are the most important parts of the trial, not the cross-examination and closing arguments as often is represented on TV. Selecting who is responsible for rendering the verdict is, of course, paramount. Opening statements provide that first chance for the parties to connect with jurors and tell their side of the story. The role of the jury is not passive. Jurors serve as the trier of fact. They must actively evaluate the evidence and decide who and what to believe. To operationalize these concepts, let's consider the structure of a civil trial. There's 3 basic stages: pleading, discovery stage, and trial stage. And remember, a civil action is non-criminal complaint involving private property rights. So the 3 stages of the trials are pleading, discovery, and the trial itself. A civil proceeding starts with the filing of a complaint or a lawsuit, which identifies the party, outlines the alleged facts and 1 or more violations, and it presents a demand for relief. Once a defendant has been served with a complaint, that individual or entity has a limited amount of time, typically 20 days, to respond by filing an answer. The answer addresses each paragraph of the complaint by admitting, denying, or claiming lack of sufficient knowledge to respond. To answer, all asserts affirmative defenses. So the answer also asserts affirmative defenses. Failure to file a timely response can result in a default judgment, which is a binding judgment against a party based on some failure to take action, like if you're forfeiting something in sports. Discovery allows for the gathering of information from the opposing party as well as third-party witnesses. Information is typically gathered or discovered via a request for production of documents, subpoenas, interrogatories, and depositions. In federal courts, this discovery process in a civil case is governed by the Federal Rules of Civil Procedure, FRCP, Federal Rules of Civil Procedure. So the discovery stage. In federal courts, the discovery process is governed by the Federal Rules of Civil Procedures, specifically Rules 26-37.9. Although states may determine their own rules, most have adopted rules that are modeled after the FRCP. There are certain rules that are of particular interest to forensic accountants. Rule 26A2. So 26A2. This rule requires the disclosure of all experts, such as forensic accountants, expected to testify at the trial. This disclosure is generally accompanied by the expert's written report, which has to contain all of the following elements. It has to have a complete statement of all the opinions the witnesses will express, along with the basis and reasons for these opinions, the facts or data considered in forming these opinions, any exhibits that were used to summarize or support the opinion, the witness's qualifications, including a list of publications authored in the preceding 10 years, a list of all other cases in which the witness has testified as an expert, either at trial or by deposition during the preceding 4 years, and lastly, a statement of the compensation to be paid for the study and testimony in the case. Then we have Rule 26B1. And this rule limits discovery to non-privileged information. Thus, it excludes any privileged information. Then we have Rule 26B4, and this rule limits discovery of an expert's communication with engaging counsel and any report drafts that may be prepared. It also limits discovery of the facts and opinions held by an expert who is engaged to assist counsel in trial preparation, so a consulting expert, but not expected to be called as a witness. And lastly, Rule 26E2. This rule requires a testifying expert to supplement his or her report to include any changes or additional information that has not been previously presented but is expected to be offered at trial. So the rules of discovery not only identify the various methods by which certain information must be disclosed, but also prescribe means by which other information can be protected from disclosure. This may involve information protected under the attorney-client privilege or work product doctrine, expert report drafts, and communications with engaging counsel. Given all of these complexities, the forensic accountant, whether it is a consulting or testifying expert, must have a working knowledge of the entire discovery process. This is necessary to not only assist counsel in complying with the disclosure requirements, but also to avoid interfering with the protection of any privileged information. The rules also frame the testifying expert reporting duties and responsibility. Violations or failure in this regard can damage the client's case and possibly even result in court sanctions or malpractice allegations against the expert. Trial stage. So after you're done with discovery, the proceeding advance to the trial stage. In the case of a jury trial, this stage begins with the selection of a jury. The jury is selected through a process known as voir dire, wherein the judge and the attorneys question prospective jurors about their backgrounds and beliefs. The selection of the jury is a critical part of the trial. Generally, there are 12 jurors in a criminal case and 6 in a civil case. These individuals collectively serve as the trier of fact with the responsibility of rendering a verdict. Following jury selection, the attorneys for both parties make their opening arguments or statements. The first to present is the plaintiff, whose opening statement serves to outline the theory of the case and any supporting evidence. The plaintiff is followed by the defendant. After opening arguments, the plaintiff presents its witnesses, which the defendant may cross-examine. The plaintiff continues the presentation of its case, which is known as case in chief, until complete. A similar process is then followed by the defendant. After the defendant completes its presentation, the plaintiff is afforded an opportunity for rebuttal witnesses, which is then followed by the defendant's opportunity to sub-rebuttal witnesses. Closing arguments are the last opportunity for the parties to summarize the testimony and highlight key points. Following closing arguments and instructions by the judge, the case proceeds to jury deliberation. During that time, the jurors collectively evaluate the evidence to render a verdict. The basic structure of a criminal case is similar to that of a civil case, with the addition of a fourth stage, sentencing. So criminal cases are initiated with a criminal complaint accompanied by an investigator's affidavit that summarizes the evidence against the defendant. During the first appearance or the arraignment, the defendant is informed of the charges and advised of his or her rights. At that time, the defendant also enters a plea to those charges, guilty or not guilty. Then discovery stage happens, and then the trial stage happens. If the defendant is found not guilty, the case is over. If it's found guilty, the case then moves to the sentencing stage, and the verdict in the criminal case, guilty or not guilty, differs from the verdict in a civil case, wherein the defendant is found either liable or not liable for damages. So prior to sentencing by the court, the case is evaluated by the probation department, which prepares a pre-sentencing report, PSR. The pre-sentencing report summarizes the case, including the crime, the case facts, and the offender's profile, and offers a recommendation for sentencing. And here you see a comparison of the key elements of the civil and criminal cases in this table.